I'm going to ask you one last time.
Okay.
Don't interrupt me. You do it again, you're going to be escorted out of the courtroom.
I'm going to go anyway.
Mr. Deputy Tover, you can get him out of here.
Ms. Pew, don't speak over me. Ms. Pew, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me.
Specific. I'm going to say it specifically like he said it. She's white. You're black. Understand where you're at. It's not going to go the way you're thinking. You really think they're going to listen to you? You think they're going to listen to anything you have to say with your record and all that?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that their first duty is to the state and will be considered conflict of interest.
Mr. Williams?
Yes, good afternoon, Your Honor. How are you today?
I'm well, sir. How are you doing?
Doing very well. Judge, I have one client there, Henry Lee Davis. He's in your jury box over there. He should be.
Okay, Mr. Davis.
So, State of Florida versus Henry Lee Davis, Your Honor, I have two case numbers, 24 CF 42 and 24 CF 59. Your Honor, we're presently on a trial track for that October 28th date. Mr. Davis has rejected the state's offer at this point, which was the lowest permissible sentence offer. So I just request that we stay on track and maybe come back on that 10/25 for another trial management in case we have a resolution.
Okay, so we'll see for trial. Yes, sir.
May I speak to open court? Okay, he's not representing me properly. I don't feel like I'm being represented properly by him. That man is the man that said, "Oh, just take the charges, just take it, you did it, whatever, just be done with it, just be okay. Just this is low permissible." I've read up on it and it says not exceeding within 5 years on this charge of third-degree felony. This man saying, "Oh, they can give you 10 years. The charge holds 10 years, just take 5 and you'll be okay." I don't feel like he's want to represent me. I don't feel like he's willing to represent me. I don't feel like he's capable of representing me.
Okay, you'll raise your right hand.
Yep.
And everything you told me, Mr. Davis, is true and accurate to the best of your knowledge. You're asking that I discharge Mr. Williams?
Yes.
But if you want me to discharge Mr. Williams, what I'm going to do, I'll ask Mr. Williams a few questions. And if I don't find that he is rendering ineffective assistance to counsel, you can still discharge him if you want, but the state will not be required to give you or provide you any other counsel. You will simply have to represent yourself.
All right.
So you're telling me that the state's offer is 5 years DOC?
68.4 months.
68.4 months. And you're saying because the charge is a third-degree felony, it says it cannot exceed 5 years?
That's what it said.
And Mr. Williams is telling you that, in his opinion, you should accept the 68.5 months.
Yeah, he said I should accept the 68.4 months. I got to know where I'm at and realize what's going on. And I'm Pacific. I'm gonna say it specifically like he said it. She's white. You're black. Understand where you're at. It's not gonna go the way you're thinking. You really think they're going to listen to you? You think they're going to listen to anything you have to say with your record and all that? Like, there's no way you should be my lawyer saying nothing like that at all to your client.
All right, Mr. Williams, anything in response?
Yes, Your Honor. I guess I'll start with that most recent statement made. Of course, I categorically deny that. I never said anything like that. The only time the whole subject of racism, if you will, came up was when he brought it up that he felt like he was a very racist town and that he wouldn't get a fair shake. And my only response to him was, I have not had that experience in Gulf County that it was racist. With regard to the maximum punishment, the reason first of all, we have two cases. They're both third-degree felonies. So I'm not sure Mr. Davis understands, although I tried to get him to understand, that each one of those cases as a third-degree felony carries a 5-year maximum. So when you total them up which is what his total exposure would be, it's 10 years. The reason that the state's offer is so high, what initially you might think is so high is because of his prior record. Your Honor. The score sheet, he scores out to 68 point something months. But I never told him nobody would ever believe him, that sort of thing. I said, we basically discussed what his side of the story was, so to speak. And I just said, well, what about this with regard to the evidence? And then I said, well, what about this piece of evidence? How do you think the jury is going to react to this? How do you think the jury will react to that? I was basically just trying to get him to see what happens when you get into a courtroom with the jury present and the presentation of the evidence. It's just the kind of conversation that I and other defense counsel have with practically every client.
Okay. Yes, sir. Mr. Davis.
Okay. So, the conversation where he said, the other case that you have that you caught here in the jail, he said, that's going to hang over your head. We're going to deal with this charge first. This is the charge that we're at right now. The other charge is going to hang over your head. And sooner or later, once you get over trial, whether you more likely lose, they're going to throw that charge out. The charge is going to be threw out. They just want you to accept this charge. That's what he said to me. This man is continuously on the screen lying to y'all. This man is like very incompetent. The man came in up being rude off bat. He came in up being rude. It took me a minute, but I was calm. I was very calm with the man. The man told me he come out and he tell the officer, "Oh, we're having communication issues." No, there are no communication issues. You're sitting here trying to tell me to take something, and then you're trying to lie and fabricate it and make it seem good in your little way. But that's not the case. Everything I told him, I say, hey, listen, half of these charges that are on my score sheet are not me. It did not happen. I received 2 different sets of charges of priors that was not my priors. He said, "Oh, we'll deal with that when we get in the courtroom." Haven't yet to say anything about it. Then you tell me, what he said. He said, I told him I said, I have a felony battery. I should not have a felony battery on this charge. It's caused of the mess. We'll get to that later. We'll get to all of that later. We'll deal with all that when it comes. We're not going to deal with that right now. We're talking. No, this is the charge that I'm on. Every time I tell him about something, that doesn't matter. That doesn't matter. That doesn't matter. How you going to tell me something don't matter? If it matters to me, it matters. You can't tell me something don't matter. You're supposed to be my lawyer. You ain't even representing me right. They just sit up there on the screen and try to lie, to try to make it seem good in your eyes. Come on, man.
What specifically about the felony battery? You said it should not be a felony battery.
Okay, I have a felony battery. And I've talked to my people. My people have been in contact with lawyers. They've been in contact with the state attorney down there in West Palm, where I'm from. And they have said, you have a felony battery, which you should not have a felony battery if y'all was living under the same roof. And both, if you claim she hit you, she claim you hit her, both of y'all should be arrested. Neither one, Drew is arrested, not her. And you have a felony battery, which should not be. It should be a domestic violence charge. I don't have no prior domestic violences. I have none of that on my record.
Are you talking about a pending charge right now?
I'm talking about the felony battery I have right now pending.
Okay, I have the battery in detention facility. What's the felony battery charge number?
2442, Your Honor.
And what does West Palm Beach have to do with this?
That's where my mom's at right now, and that's where she's talking to lawyers and getting in contact with people down there. I'm trying to figure out what's going on up here, because she's been trying to contact people up here and it's not working. Nobody's calling her back. Nobody's emailing back. When I had Mr. Hill, my family was trying to get in contact with him. They never could get in contact with him. My family, I've tried to get his information. He told me he didn't have any cards to give me.
If I could, Your Honor.
Mr. Hill, I've talked to Mr. Hill priorly. When I talked to Mr. Hill said, I checked that you don't have any prior batteries. But then next thing you know, I get a prior sheet with prior batteries on it. Like,
the state's not charging you with felony battery based on priors. They're charging with felony battery, saying that you caused great bodily harm. That's what we're talking. That's what we talked about the first time. But I'm saying my score sheet, as he just said, my score sheet, I should not score out to that much because I don't even have none of them priors. I have about 4 or 5 or 6 priors that are me on them. They don't even have the priors that I went to prison for on them. That's how I know you're just trying to stack charges and trying to make it look like something that is not. Well, when you're telling me that Mr. Williams is not rendering competent and constitutionally effective counsel. I need to go issue by issue. That's why I'm at. You raised something about a felony battery.
Uh-huh.
What about your charge of felony battery? That you're saying your mom or someone from Fort Lauderdale disagrees that you should be charged with that? West Palm Beach.
She don't disagree. She's saying it's wrong. It is wrong. And if we're staying under the same household and we had sexual relations, it should not be a felony battery. And especially if I said that she hit me and she say I hit her, they don't take her to jail, but then they take me.
That's a question. That's a question for the jury.
But it's not a question if it's a wrongful charge. You have me with the wrong charge.
Mr. Davis, listen.
Here, all you have to do is look at the paperwork.
Mr. Davis, whether you're living in the same house with someone or not, you can be charged with felony battery.
Are you sure?
Listen to me, Mr. Davis.
I mean, I have the evidence. I have the proof. I mean, if I'm looking it up and I'm finding this, my people are looking up and they're finding it, and they're asking other lawyers and other state attorneys, and they're saying the same thing. Y'all are going to say something different from what everybody else is saying. This is for the whole state of Florida. I've been on the phone constantly.
I agree with you.
I've been talking to people constantly. You cannot charge me with a felony battery. Felony battery is like if I go off out there and go to hit somebody. That's a felony battery. If it's somebody that I'm living under the same roof with, and we're having sexual relations, because it's what it said. I mean, I've read up on it. I had my people look up on it. They've read it to me. I've written it down. I've talked to my people. It's a DMV. So I don't get why y'all having a felony battery when it's not supposed to be a felony battery.
So you're under some lawyers telling you that regardless. Listen to me. I'm trying to understand. Your family or a lawyer or whoever they're talking to is telling you, regardless of the amount of damage that you allegedly cause, that you can cause permanent disfigurement, great bodily harm.
No
I'm not saying you did. Listen to me.
I walk in this courtroom 10 times.
Mr. Davis.
Come on, man.
Do you want to have this conversation to get through this, or you want to tell me what you want to tell me?
The conversation don't seem like it's being understood by nobody. Because you're telling me, oh, it don't matter this. I'm telling you, if I'm giving you this and you're trying to give me something else, but I'm giving you what the law says. I've read in the law books and all. I've been in the law books. My people are looking it up and getting the same thing. You're trying to tell me something different to make me think that, oh, no, what you're saying is not right. When I know it is. If everybody's looking it up, I have different people looking it up out there. Everybody's telling me the same thing. I have people in here look it up. I've looked it up. I've even talked to Mr. Hill about it. I should not have a felony battery. There's no way I should have a felony battery on this charge. No way. And then they talking about my priors. That's not even me. Then you said, you should just take the charge. There's no way I should just take the charge.
We're going to get to your priors. Let's stick with the felony battery. Are you finished?
That's what we're talking about.
Are you finished?
My priors leads up to that felony battery.
Are you finished?
Come on.
Are you finished?
Come on.
If you're going to have a conversation with anyone, a part of it is listening, okay? I'll listen to you. Listen to me.
I'm listening.
You can be charged with felony battery based on two things, Mr. Davis. Felony battery based on priors. The state has not charged you with felony battery based on priors. They charged you with felony battery based on great bodily harm or permanent disfigurement. And it doesn't matter if you two live together or not. Now, if you're saying that whatever harm the state is alleging doesn't rise to that level, that's a question for the jury. Okay?
Can I say something again?
The defendant is trapped in a cognitive loop. He believes that because he lived with the victim, the charge must be lower. The judge offers a lifeline, explaining that great bodily harm legally overrides the relationship, but the defendant rejects it because it contradicts his survival narrative.
Yes, sir.
Okay, so we're going to go back to what you just said now. We're going back to what you just said in the beginning. They're not charging me on my priors. I know that. Okay? But they're trying to sentence me on my priors. Okay.
We haven't got to that point yet. We haven't got to.
You literally just.
We're talking about felony battery. We haven't got to the score sheet.
So we're going to talk about this.
Yes.
Okay. So now we're going to talk about felony battery, right? You saying no matter the disfigurement or the bodily harm, you yourself.
I didn't say no matter the disfigurement.
You said no matter the disfigurement that if I cause disfigurement and all of that.
Permanent disfigurement.
But you yourself watched her walk in this courtroom, as well as other officers walk in this courtroom, get out stumping. You've even said.
I don't know who you're talking about.
You've even said something to her when I was standing up here.
I can say something to whoever I want to.
You see,
but listen to me, Mr. Davis.
Now you're just trying to, okay.
I don't know.
You want me to be quiet?
I don't know who the victim is. I don't know what the allegations are.
I'm telling you now.
Okay.
When she sat right there and I was standing up here, her and her sister went to snickering and everything, you said something to her. Y'all gonna have to get out of this courtroom, get out of here. We're not with all of that.
Okay.
And they got up and walked out.
Okay.
You telling me you didn't see none of that? You haven't seen it, watching nothing. You don't even remember that. Not even remotely remember that at all. I'm talking to you man to man, not judge the inmate. I'm talking to you man to man. Like, you telling me you haven't seen that?
Well, let me clear that up. This is judge to inmate.
I'm about to worry about it. Man, listen, we're men. I'm asking you a simple question. Did you or did you not see her sitting there when you said something to her, get up and stomp off?
Have you received a copy of your score sheet?
Yes.
And what
I like how you stopped that.
priors on your score sheet you say are not yours?
A bunch of them. As I've said to him on the first time he sent the score sheet and the second time he sent the score sheet.
Have you explained to Mr. Williams what priors on your score sheet you believe are not yours?
Yes.
Mr. Williams, you want to respond?
To Mr. Hill too.
Mr.
Yes,
Williams, you
sure.
want to respond to the score sheet issue?
Yes, Your Honor. We went through the score sheet and I went down the score sheet with regard to his priors, offense by offense. And I took notes to the ones, there were 2 or 3 to my recollection. I don't have notes in front of me. He basically felt there 2 or 3 of them were not him. I said, and I marked those.
You're lying.
Mr. Davis, don't interrupt.
Oh, hey, listen. Just take him off my case. I don't want to talk about it more. Just take the man off my case. I'll do what I got to do, man. Just take him off my case.
Mr. Williams, continue.
Take him off my case, man. I don't want to talk about him. He's lying. You're going to continue to listen to this man lying, man. Don't do that.
As I recall, there were approximately.
I'm going to ask you one more time. Don't interrupt. We're in the courtroom. Just be respectful.
I don't want to talk about it no more.
Whether you want to talk about it or not,
I just want him off my case.
I have a legal obligation to go through this hearing with you.
Him off my case.
Mr. Williams, continue.
Yes, Your Honor. As I recall, there were approximately 10 or so priors. There were enough that on the supplemental score sheet, it was full, as well as the space on the first page of the score sheet. And I went through each and every one of those with Mr. Davis and asked him, because he had made sort of a general averral that some of them were not him. He wasn't involved in them. They shouldn't be on a score sheet. I said, okay, let's go through them. I went through every one of them. As I recall, there were 2 or 3 that he said, that's not me. I didn't do that. I was never convicted of that. So I took those notes and I told him, okay, I can't give you an answer right now. I'll look into it. And before we go to trial, this will get resolved. You know, I didn't have the resources to look it up right then in the jail. So that's the long and the short of it.
Have you reached out to the state to confirm whether or not the priors on the score sheet are actually Mr. Davis?
I have not, Your Honor. I saw this was a meeting in the jail that I had with Mr. Davis. I believe it was last Thursday, and I haven't had the opportunity to reach out to the state as I'm out of town right now. I went out of town on Friday and haven't returned yet. But of course, that is my plan, to reach out to the state and even to, conduct independent sort of investigation with regard to it if I have to.
Okay. All right, Mr. Davis, anything else?
Take him on my case.
All right, Mr. Williams, anything else?
Nothing, Your Honor. Just the first thing that you were discussing with him with regard to the felony battery thing, that's just his position. I think he finally made it clear is that he believes, since he was in a domestic situation with the alleged victim, that therefore the maximum charge.
I went in no domestic situation. Don't say that, because I didn't say that.
Is a misdemeanor domestic battery. So I explained to him that when the state charges great bodily harm, it doesn't matter what kind of relationship you have with the victim, it's a felony.
You said that? You said that to me?
Thank you, Mr. Williams.
Okay, I thought so.
All right, Mr. Davis, on the issue you raised, the felony battery, I've told you what the law is. Regardless, the state's not charging with felony battery based on priors, and
But y'all
regardless.
have your own law here?
I'm going to ask you one last time.
Okay.
Don't interrupt me. You do it again, you're going to be escorted out of the courtroom.
I'm going to go anyway.
Mr. Deputy Tover, you can get him out of here.
Hey, but I'm push. Hey, don't push me. Cool.
All right, as to the felony battery, the state's charged him with felony battery based on great bodily harm, permanent disability, or permanent disfigurement, not based on priors. The priors on the score sheet, Mr. Williams, you indicate you two did have that conversation. You're going to conduct an independent investigation. Also reach out to the state to see, confirm whether or not the priors on the score sheet are actually Mr. Davis's. As to the credibility issue, if it's her word versus his word, that does come down to the jury making that decision. On the racial terms, you tell me you did not make those comments, and your opinion of whether or not he needs to accept the plea offer is not ineffective. So based on what I heard today, I'm not going to discharge Mr. Williams. I'm not going to find that he is rendering ineffective assistance of counsel. And that'll conclude the Nelson hearing. Anything else on this case today?
That's nothing else from me, Your Honor, except I would request that just in case we do get a resolution before the October 28th, that we come back on that October 25th date as well.
Yes. And I'm also need to put on the record that Mr. Davis was disruptive of the proceedings, and he was removed from the courtroom prior to the conclusion of the Nelson hearing. We'll come back on October 25th for trial management, and we'll have jury selection October 28th.
And that October 25th, I believe you said, was at 9:30 Eastern time?
Yes, 9:30 Eastern time.
Thank you, Your Honor. You have a good day.
You as well, sir.
Good morning. Are you Janetta Pew?
I am the beneficiary of that estate.
You're the what?
I'm the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pew and her family has retained an attorney on this matter. You may, I don't know if you remember, Judge, this is when I was originally appointed on, and we were on the trial docket. She hired a new attorney at that point. Mr. Norwood, who was on the case for a while, and then withdrew. And once recently, when the case came back to me, I visited with her, and I was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the court.
Okay.
But I've been told that that's who's supposed to be taking over the case.
Okay.
For the record, I recognize Ms. Pew. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pew's behalf.
All right. So, Ms. Pew, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody, and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest. Your Honor.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel effective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Ms. Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Ms. Pugh, don't speak over me.
Respectfully, Your Honor, for my incarceration.
Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed.
Go back.
Agents.
You already said that, and that's overruled. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.
In the first case, Mr. Davis attempted to litigate from the defendant's chair. He fixated on a domestic technicality, convinced that because he lived with the victim, the great bodily harm statute simply could not apply. The judge offered him the precise legal key to his case, that the severity of the injury overrides the domestic relationship, but Davis threw it away. He was so committed to his own interpretation that he refused to learn the actual danger he faces. He treated the law as a negotiation, believing that if he argued loud enough, the statute would bend. Then we saw Ms. Pew, who escalated this denial into total fantasy. She deployed the classic sovereign citizen script, demanding verified claims and speaking of trusts to dismantle a criminal indictment. Like Davis. Fine, she believes that if she simply repeats her personal definition of the law, the court will eventually capitulate. She attempts to use pseudo-legal buzzwords as a shield, not realizing they are transparent to the court. Both defendants view the courtroom as a debate stage where they can consent to the rules. They fail to realize that the rules were set long before they arrived. The court does not require your consent to prosecute you, and it does not require your understanding to incarcerate you. Mr. Davis goes to trial with a lawyer he fundamentally misunderstands, and Mrs. Pew goes to jail waiting for a magic trick that will never work. When you replace legal strategy with ego-driven defiance, you cease to be a participant in your defense and become merely a spectator to your own sentencing.